Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about suing tribunals. Cases that should have gone to the Supreme Court of Canada, but didn't. Wendy Ho was employed in Ontario by an Ontario healthcare system, and ultimately during the course of her employment, she suffered discrimination and harassment, she claimed, that led to her leaving her employment, and she sued for compensation. Her compensation claims were addressed in the Ontario Employment Standards Tribunal, and in the course of addressing those claims, her claims were dismissed. Ms. Ho then decided to sue the tribunals for failure to protect her from the illegal acts of her former employer, and her claims were struck on the basis of the fact that tribunals were insulated from being sued by individuals. And while it is true that tribunals are technically supposed to be insulated from being sued by individuals, tribunals are not the same as judges. The constitutional guarantees that protect judges from being sued in the course of their duties have to do with the sort of independence of the judiciary and the protection of judicial decision-making. But tribunals don't perform the same functions as judges. They're not expected to have the same level of expertise. Their decisions are reviewed on different standards. The determinations that they make are subject to different types of intervention, and they're supposed to be experts related to the subject matter of the issues that come before them, but may get it wrong and in fact are expected to sometimes get it wrong and are not held to a standard of perfection or completeness in the decision-making. So if a tribunal isn't the same, and tribunal members of course are not given the same security of tenure and same payment as judges get, if tribunals are not the same as judges and aren't treated as such, should they enjoy the same protections? Now, I'm not saying that in every case a tribunal should be insulated against a lawsuit, but if there is no real mechanism to control the actions of a tribunal, that judicial review is essentially constrained in the sense that judges can't substitute their own judgments or their own views of the evidence, that judges are sort of constrained in reviewing only the reasons for reasonableness and the outcome to determine whether it fits within the range of possible acceptable outcomes defensible in respect of facts and law. Are we not essentially creating a lawless institution or a series of lawless institutions that can't be held to the same standard? And by treating tribunals as having the same type of protections that judges get, while still not treating them as judges, but in fact giving them more deference in many circumstances than judges would get for their decisions, do we not encourage bad actions? That's not to say that in Ms. Ho's case the tribunal acted improperly, or that even a majority of tribunals, if at all, are going to act improperly, but where is the protection for the public against improper actions by tribunals? We have seen them. There have been cases where issues have gone to the Supreme Court of Canada, in fact, with tribunals acting improperly, but the remedies are the remedies constrained by the powers of judicial review. And by not holding tribunal actors and the tribunals themselves, which are essentially extensions of branches of government, as opposed to an independent branch from government, accountable for their actions through the potential that in some very unique and specific and delineated circumstances they could expose themselves to civil liability, are we not essentially just endorsing a lesser version of justice for anybody who is going before a tribunal? I'm reminded of comments made by Joe Arvey in a case that dealt with whether or not the Crown prosecutors could be sued for improper conduct in the course of their quasi-judicial and quasi-ministerial exercises of discretion, where Joe Arvey said, "What's so special about Crown counsel?" in his submissions to the Supreme Court of Canada. And I have to ask, what's so special about tribunals that they, in many respects, get more protections and insulation for their decisions and decision-making power than actual judges sitting independently of government? This obviously raises important issues that the Supreme Court of Canada should have addressed. And if the rule is that tribunals can never be sued, then one would expect the Supreme Court of Canada to provide some justification for why that is the case. And unfortunately, the Supreme Court of Canada has sort of left us in a situation where some people are going to feel uncomfortable about the state of their decisions and the state of their cases when being dealt with by tribunals because they have little to no opportunity for remedy. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Rosenville Creative for putting together these videos. Please like, subscribe, and share with your friends.